All right, let us go ahead and get started. I believe other people are going to trickle in, but I don't want to lose any precious moments from you being able to hear from our guest speaker today for the Tetley Lecture in Maritime Law, which we are excited to welcome everyone to today. The Tetley Lecture, what you may not know about the Tetley Lecture is it honors a truly towering figure in maritime law, namely this person, William Tetley, who has particular ties to Tulane. William Tetley was a professor here at Tulane, but he led not one career, just a distinguished career in academics. He actually led 3 different, very distinguished careers. A graduate of McGill University and the Law Faculty of Law School, Professor Tetley first built an acclaimed career as a practicing lawyer. He practiced for nearly 20 years with one of Canada's premier law firms, and Professor Tetley attained the rank of Queen's Counsel in 1968. Professor Tetley then transitioned into a high-profile career in government service. So he moved on from just being a practicing lawyer to being a government lawyer, ultimately as a member of the Quebec National Assembly and a cabinet minister. And only at this point, after achieving all of those wonderful credentials, Professor Tetley launched his career as an academic. He first joined the law faculty at McGill University in Montreal, and over the next 3 decades, Professor Tetley established himself as one of the international leading scholars in maritime law. Now, for 15 years, we at Tulane were fortunate to count Professor Tetley as one of our own. From 1984 to 1996, Professor Tetley served as a visiting professor at Tulane, traveling annually to New Orleans, and as he put it, and I will quote now, going south each winter like a Canadian goose. And he came here to teach a course at the law school in Admiralty Law. He was beloved by students and by colleagues alike. In 2001, after he stopped being a visiting professor at Tulane, the law school created this lecture series in his honor. And it was a bit unusual, and I don't want anyone who's thinking about doing this to think we would do this today. It was an unfunded lecture series, which is not the way we like to do things now, but an unfunded lecture series, and truly just a tribute to a former colleague, an old friend, and a real leader in the world of admiralty and maritime law, something that is so important at Tulane Law School. 10 years after this lecture series was created, in 2011, Professor Tetley learned this piece of trivia, that this was an unfunded, somehow endowed, unfunded lecture series. And so he generously gave himself so that he could endow this lecture series in perpetuity. Tulane's tribute to an eminent scholar, to a dear friend, and to a colleague, to so many in this room, was thus returned and demonstrated yet again what a special person Professor William Tetley was. Through the years, the Tetley Lecture has attracted leading figures in the maritime field from around the world, academics, folks from industry, individuals who served as government attorneys, much like Professor Tetley in the second part of his career, folks in legal practice, like the first part of Professor Tetley's career. And today, we are truly privileged to continue in that tradition by welcoming Justice Sarah Derrington of the Federal Court of Australia. I could go on, but as I always say at these, you're not here to hear me. You hear me all the time. Instead, let me now introduce and turn it over to my friend and my colleague, Professor Martin Davis, who runs our Maritime Law program, to introduce our guest of honor today.
Well, you're not here to listen to me either, so I'll make this as brief as I can. But to introduce Sarah Derrington is actually no small task, because she has led an extraordinary career. Before she became a judge, she was an academic at the University of Queensland, became the Dean of the Faculty of Law at the University of Queensland. God bless her. Later, sorry, Sarah, later became president of the Australian Law Reform Commission, and And I'm just going to list a few of her sort of previous, and I promise this is not all of them. Former president of the Maritime Law Association of Australia and New Zealand, a member of a fellow of the Australian Academy of Law, a titulary member of the Comité Maritime International, a fellow of the Queensland Academy of Arts and Sciences, an honorary bencher of Gray's Inn, the Inn of Court in the UK, a member of the Order of Australia. That's just some of it. Sarah is an extraordinarily accomplished maritime lawyer, as well as all of the stuff that I didn't quite get through all of. She is also co-author of books both on admiralty jurisdiction and procedure and substantive maritime law, which the maritime lawyers in the room will know is like the full house. So without further ado, Sarah Derrington.
Didn't switch my PowerPoints as you promised.
This is a dean's job at any point, as you know, from your time. It's all right. Don't worry.
Maybe one job.
So Martin did not share that Sarah was also the first female law dean at Queen's, and so congratulations.
So the first female professor. It took a very long time in Queensland for anyone to catch up.
Congratulations. No, certainly.
Well, Jean Sally Richardson, Professor Martin Davis, Professor Robert Force, and distinguished guests all. It is a real pleasure to be here with you this afternoon, and I'm very grateful to Professor Davis and the Tulane University Law School for inviting me to be here. For those of you who are too young to have met Professor Tetley in person, I was going to paint you a picture of him, but now you've seen him, and I don't need to do that so much. I hate to contradict your dean. He had a towering intellect, but he was not a towering man. He was a very small man, and always with the ubiquitous bow tie. He was the archetypal professor of the era. He spoke several languages, and he was an excellent ballroom dancer. And I had the pleasure of being turned around the floor once or twice by him at CMI conferences. He's still missed very much by the Maritime Law Academy. And as you will note throughout this paper this evening, there's not much that one can say that's too original. He has commented on everything and anything over the period of his academic career. Now, in his fourth and sadly final edition of his text on marine cargo claims, Professor Tetley expressed his regret at the gradual shift over the last 2 decades away from the degree of international uniformity in carriage by sea law that had been achieved previously. Since making that observation, almost another 2 decades have elapsed, and the shift appears to have been rather less gradual over those decades, confined not merely to carriage by sea law, but including other areas of admiralty and maritime law, once seen as more or less universal. As 2 of my colleagues and I observed in our judgment in Poraloo Marine Australia Proprietary Limited and the MV Dijksgracht delivered in September of 2023, it will be a century next year since the first attempt at achieving some level of universal uniformity in respect of a cargo liability regime for the international carriage of goods by sea. On August 25, 1924, the Hague Rules opened for signature. These rules were amended on February 23, 1968 by the Visby Protocol, and then again on December 21, 1979 by what's called the SDR Protocol. And together, those of you who are maritime law students will know that these are called the Hague-Visby Rules. 2 subsequent attempts have been made to modernise the cargo liability regime through the Hamburg Rules, which entered into force on November 1 of 1992, and the Rotterdam Rules, which opened for signature on December 11, 2008, but these have not been met with international acceptance and are not really presently relevant. Now, those observations, which I've paraphrased from the judgment, were made to explain why in 2023 there remained uncertainty as to whether the almost 100-year-old Hague Rules applied to a contract of carriage negotiated in late 2019 by a French ship and chartering broker with a Dutch carrier. The contract involved a shipment from Ireland, a country that has not ratified the Hague-Visby Rules, but has enacted them by domestic statute, to Australia, which has enacted a version of the Hague-Visby Rules, modified by domestic statute, despite having denounced the Hague Rules, and to which the consignee asserted that English law applied. Now, my purpose today is to discuss whether the idiosyncratic approach of individual nations to the development of maritime law, be that by statute or judge-made law, has already done sufficient damage to the prospect of real international uniformity in an area of law that must, because of its very subject matter, be transnational. And if so, whether there is any real international will to reverse the damage. And I propose to illustrate some of the idiosyncrasies by reference to the law relating to carriage of goods by sea, and I think quite presciently in the circumstances that have occurred in Baltimore this week by reference to limitation of liability. But first, why is international uniformity worth pursuing? The arguments in support of a uniform international maritime regime are hardly new, but in an area of law where national and international laws prevail over the general maritime law, it does not hurt to restate the two most important reasons for a degree of uniformity. At a time when maritime trade was central to the development of commercial law, Lord Mansfield said in 1774, in a case concerning marine insurance, "In all mercantile transactions, the great object should be certainty, and therefore it is of more consequence that a rule should be certain than whether the rule is established one way or the other, because speculators in trade then know what ground to go on." The second benefit has been described more recently. Uniformity seeks to provide insights into applicable rules and predictability as to the outcome of disputes, equal results from equal rules. And essential clarity about the practical implications of any attempt to institute international uniform law is found in acknowledging the primary quandary of international uniform law. Indeed, as it was put by Dr. Camilla Anderson, in our world of globalization, we have seen the diffusion of laws and efforts to achieve legal convergence, resulting in attempts to create laws that are internationally uniform, but very rarely do we see attempts to define what this means. Professor Michael Bridge, who is a colleague of Professor Davis at Melbourne University, said this: "Uniform law represents a part of that phenomenon that we call globalization, a word that means so many different things to different people and ought on that account to be used sparingly. Perhaps with a moderate financial forfeit that upon sufficient accumulation will be paid over to charitable purposes. Those of us participating in one or more of the incremental effects to bring about uniform law are, fortunately, sufficiently obscure to be spared the attentions of the anti-globalization professors. So here we are with our interest in a topic, or so I assume because you're here, that is sufficiently obscure that I had no fear of being cancelled. Now, it's not my intention to rehearse the origins of uniform international maritime law. Attempts to bring about a lex maritima have their genesis in antiquity. And to the extent that general principles of international law are relied upon, the challenge in that respect was aptly summarised by Sir Edward Coke in the 16th century. "How long soever it hath continued, if it be against reason, it is of no force in law. Now, I don't mean to be disparaging about public international lawyers, but gentle jibes between public and private international lawyers are inevitable in this field. What I do intend to do, by reference to the two areas of law that I've singled out, is to identify some hairline fractures in what had hitherto seemed relatively solid international acceptance of a largely uniform regime by which international shipping and maritime law was to be governed. And whilst I can trace the fractures thus far, I cannot explain their cause. Perhaps it's a symptom of the redistribution of global power. Those states who once led the charge for uniformity, and here I refer mainly to the United States and the United Kingdom, may have lost a little of their charisma. Perhaps it's a feature of what has been termed post-globalisation and a refocusing by nation states on their own national interests. There is little doubt that the shift had commenced prior to the COVID-19 pandemic and has been hastened by the Russian-Ukraine war and the tragic events in the Middle East. These are no doubt questions for political scientists, not a mere Admiralty lawyer from the Antipodes. But I hope that by exposing the hairline fractures at this juncture, there may be time to patch them up before they widen into great chasms from which there will be no return. So I begin with carriage. In giving this very lecture in 2000, subsequently published in the Maritime Law Journal of this university, Professor Tetley identified carriage as one of the 12 major sectors of international law, albeit, so he thought, an aspect of shipping which he said had a disheartening lack of uniformity. Well, that was 24 years ago, and if he was here with us today, other than in spirit, I suspect he would have chosen a stronger word. The law relating to the carriage of goods has in fact displayed a remarkable degree of uniformity since the first bills of lading developed in the 15th century. The evolution of bills of lading from non-negotiable to negotiable and their eventual incorporation under the Hague Rules was born of a unified common interest in regulating freedom of contract for carriage of goods. The former Chief Justice of my court, the Federal Court of Australia, the Honourable James Alsop, AC, KC, described the development in the following way. He said, the recognition from the 1870s of the fragmentation caused by national legislation counteracting the abuses produced by unbridled freedom of contract practiced by ship owners led to the Brussels Convention in the early 1920s and the establishment of a workable compromise of minimum rights and obligations in the carriage of goods by sea under bills of lading in the Hague Rules. This long and exacting process took over 50 years. At its foundation was the need to qualify unbridled freedom of contract and to bring about a fair balance, a balance between the demands of commerce. And Professor Tetley made similar comments emphasising the critical nature of uniform development for the essential functioning of international trade by sea. Now, the judgment in the Poraloo case, to which I have already referred, makes pellucid the consequences of the lack of uniformity in international carriage, a piecemeal corpus of regulation which does no favours to those involved in commerce, but is a boon for the maritime lawyers. So that's good for us, okay? Not too many clients here, I hope. One needs to look no further than the trial judge's outline of the 4 separate liability regimes that were applicable to the facts of that case, and which by extension also referred separately to the 3 other sets of international rules that were relevant. The present state of the international law of carriage might be said to be devoid of both certainty and confidence that there will be equal results from equal rules. And it is both a cause and symptom that this is so. States have promulgated divergent and hybrid national laws on carriage in the face of now 4 supposedly uniform regimes, causing the patchwork that relates to international carriage of goods to unravel. The Hague Rules were extremely successful, with at one point 100 signatories, including the US and the UK. The Visby Protocol, which entered into force in 1977, was ratified by 40 states, but not by the US. By contrast, the SDR Protocol, which entered into force in 1984, achieved only 27. So by the mid-80s, the fractures had begun. The Hamburg Rules came into force in 1992, but with only 31 states to have ratified them, none of them being major maritime states. There was much more hope for the Rotterdam Rules, given that the US was a signatory to the convention, together with other maritime nations such as Denmark, France, Greece, the Netherlands, Norway, and Sweden. However, although there are 25 signatories who together represent 25% of the world's trade, only 5 states have in fact ratified the convention. And those states are Benin, Cameroon, Congo, Spain, and Togo. The United States, as I said, signed the Rotterdam Rules on 23 September 2009, but a key incentive against their implementation in this country is the potential displacement of or uncertain interaction with otherwise port interests already provided for under COGSA. And while the case of Federal Maritime Commission and South Carolina State Ports Authority can be read to confirm that port authorities will be protected under sovereign immunity and not liable under the Rotterdam Rules for increased risks of potential cargo damage liability as maritime performing parties, there is uncertainty still about how the rules would affect cargo litigation involving port parties who are not also party to carriage contracts. Other criticisms have focused similarly on the excessive complexity of the rules. From an Australian perspective, 3 main concerns have been articulated. First, the complexity of the instrument. Secondly, the perception that the text favoured carriers at the expense of small shippers. And the shift via the volume contract provisions from a mandatory liability regime to one based on freedom of contract. So going back to pre-Hague Rules, at least from an Australian perspective. Professor Tetley himself posited that the legal disunity flowing from the coexistence of the principal cargo regimes has encouraged a number of countries to go it alone by adopting national legislation on the carriage of goods by sea. Australia is an example of one such country. Having originally acceded to the Hague Rules and the subsequent Visby and SDR protocols, we enacted the Hague-Visby Rules by Schedule 1 to our COGSA 91. By instrument of denunciation in 1992, we denounced the Hague Rules. But then, following a departmental review in 1996, the Carriage of Goods by Sea Amendment Act 1997 was passed. That act provided for amendments to amend COGSA 91 and to add a schedule of modifications that would modify the text of the Hague-Visby Rules. Schedule 1A was inserted by the Carriage of Goods by Sea regulations, and these are described confusingly as the amended Hague Rules, which is also the name by which the Hague-Visby Rules are referred. So, 3 of us in the federal court, all Admiralty judges, have determined that in our court, they will be referred to as the Australian rules. We don't know if the rest of the judges in Australia will follow our lead, but in our court, that's what they're called. Now, a recent example of the mischief perpetrated by this idiosyncratic approach to the implementation of a convention to which Australia remains a party is the case of the BBC Nile. That case arose in the context of interstate carriage of steel railway tracks from a port in South Australia, which is where the yellow arrow is, all the way around and up the coast of Queensland to where the red home symbol is, to the port of Gladstone in Queensland. So that was a carriage entirely within Australia, but it was done pursuant to a bill of lading with an English choice of law clause and a London arbitration clause. Nobody knows why. The question was whether the clause was invalid because of the operation of a particular section of COGSA, the Australian COGSA, which provides that a provision purporting to limit the jurisdiction of an Australian court in respect of a bill of lading or a sea carriage document for inbound international carriage has no effect. If the arbitration clause was valid, it was then necessary to consider whether its effect was to lessen the liability of the carrier, contrary to Article 3, Rule 8 of the Hague-Visby rules, because the arbitral tribunal would not apply the Australian rules, which in some respects are more favourable to cargo interests than other Hague-Visby rules. The full court of the Federal Court stayed the Australian proceedings in favour of arbitration in London, albeit on various undertakings that were given that I won't discuss with you now, and found that the plaintiff, Carmichael, had not established that there existed a risk that BBC's liability would be relieved or lessened as a consequence of three matters it had identified, being a possible difference of interpretation as between England and Australia as to the meaning of Article 3, Rule 2, a possible construction of the clause paramount that would see only the Hague rules incorporated, and the expense and difficulty associated with arbitrating in London. In other words, the full court took the view that the arbitrators were fully capable of dealing with Australian law, even in a London arbitration. So that was a win for the arbitrators. The matter subsequently went on appeal to the High Court of Australia, who dismissed it. Now, this very expensive interlocutory skirmish could have been avoided altogether had Australia not meddled with the Hague-Visby rules and just implemented them properly as they were written. Now, similarly, the 1993 Maritime Code of the People's Republic of China and the 1994 Nordic Maritime Code are examples of hybrid carriage of goods by sea legislation. They incorporate some elements of the major international conventions, but also contain elements that are purely national in character. The Nordic Maritime Code, which pertains to Denmark, Finland, Sweden, and Norway, but not Iceland, incorporates much of the Hamburg rules, although none of the participating countries has ratified those rules. Rather, they all formally adhere to the Hague-Visby rules. And again, as Professor Tetley commented, such hybrid enactments may meet the needs of the countries that have enacted them, but seen in a wider international perspective, they serve to further exacerbate the prevalent disharmony of law plaguing maritime commerce today. Now, in this country, and I stand to be corrected, a reading of sections 13 and 1E of your Carriage of Goods by Sea Act modifying the Hague rules, which abrogates the application of the Harter Act to the tackle-to-tackle period for international carriage, means that the parties' liberty to extend COGSA's application contractually to any damage or loss of cargo in preloading and post-cargo discharge periods, or alternatively, rely on the default application of the Harter Act, creates a lack of certainty around liability. And this seems to be only compounded further by judicial disquiet over the meaning of a package under your COGSA. Now, of course, once upon a time, fragmented national regimes could, if functional, provide templates for model international law. And in the past, the development of uniform law by customary hybridisation has provided a standard around which international law for carriage can develop based on such a national statute of international stature. But the extent to which what history has shown remains relevant today is difficult to assess, not least because of the extent to which states have, at this point in 2024, pursued non-comparative and divergent national carriage laws. The great hope for the Rotterdam rules has always been that the United States and China would ratify them and that the world would fall into line. That has not happened, nor does it seem likely that those countries which have adapted existing regimes to suit their own national interests would be interested at this point in time in revisiting such interests with their bodies politic. They are not sexy matters for politicians to enter into. I turn now to the limitation conventions. Typically considered to be the primary source of international maritime law, the status and extent of implementation of international maritime conventions are telling indications about the degree of uniformity in contemporary maritime law. The International Maritime Organization, or IMO, has adopted a comprehensive limitation of liability and compensation regime that is designed to ensure that claimants receive prompt and adequate compensation without the need for legal recourse. The regime is the result of a carefully negotiated compromise that balances the obligations and interests of governments, claimants, and industry. Limitation of liability is, of course, a, if not the, principal legal matter in shipping. As Lord Mustall said in 1993, ships are different. This very different ship is a Lego recreation of the Rena that some of you may have heard about, that foundered off the coast of New Zealand. And the National Australian Maritime Museum had an exhibition recreating wrecks from antiquity to modern times. So I thought you might like that photo. In addition to the LLMC 7692, the regime includes the CLC 1969, the Fund of 1971, the HNS 2010, Bunkers 2010, sorry, 2001, I can't read my own writing, and the Nairobi Wreck Removal Convention of 2007. And as the IMO has observed, the effective operation of the regime is dependent upon a uniform implementation and application that is consistent with the aims and objectives agreed at the time of their adoption. That photo is of the two finalists in the Sydney to Hobart yacht race on Boxing Day, and Law Connect eased out Comanche, who had won the 3 previous years, and that's taken from my back deck in Hobart. So that one didn't need attribution. Now, as at 24 January 2024, the LLMC 76 had been ratified by 54 states and the 96 protocol by 61, but not by the United States. Both the CLC 1968 and the Fund 1971 have also been amended by protocols, first in 1984 and then in 92. A subsequent protocol to the Fund Convention 92 was adopted in 2003, and it now provides a third tier of compensation for pollution damage in states who are parties to it. The CLC has been ratified by 147 states, which is quite a remarkable ratification rate. And 33 states are parties to the 2003 Supplementary Fund Protocol. Now, for current purposes, I want to focus on the vexed issue of breaking the limit of liability. Article 4 is the governing clause of the LLMC 7692. It was introduced in 76 and was universally acknowledged to provide a stricter test for breaking the limit than had been the case under its 1957 predecessor. The 1957 convention permitted the breaking of the limit if there was actual fault or privity of the owner. Now, that's very close to the test, as I understand it, in your Limitation of Liability Act of 1851. The stricter test was a trade-off for the higher limits agreed in the LLMC 76. The CLC 92 and the Fund 92 have equivalent provisions. And Article 4 provides that a person shall not be entitled to limit his liability if it is proved that the loss resulted from his own personal act or omission, committed with the intent to cause such loss, so you wanted that ship to hit the bridge, or recklessly and with knowledge that such loss would probably result. You knew the engines were going to fail, but you didn't think you'd bother with a tug. And you knew that the bridge would fall down. You have to foresee the actual loss that would result. Now, there are two matters arising from this article to which I wish to draw particular attention. The first is the method of attributing liability to the relevant corporate entity who is entitled to limit liability in accordance with Article 1, be that the ship owner, the salvor, or others for whose act, neglect, or default the ship owner or salvor is responsible. Now, in the petition filed by the owner and manager of the Dali 2 days ago, the owner and the manager have expressly denied fault by any of the persons for whom they might be entitled to limit. And in any event, they argue that the provisional limit should be US $43.7 million, which is probably not going to cut it. The second thing I want to focus on is the differing interpretations that have been given to Article 4 and its equivalent provisions in the CLC and the fund by other national courts. So these are the people who, under the Limitation Convention, are entitled to limit. Ship owners and salvors, who are usually corporate entities, owners, charters, managers, or operators, who are also usually corporate entities. The person rendering services might be the tug provider. They are persons rendering services and are likely to be corporate. And any person for whose act, neglect, or default the ship owner or salvor is responsible, and the insurer of liability for claims subject to limitation. And the insurance company, of course, is a corporate entity. But the LLMC is silent as to which humans in the corporate ship-owning structure should be identified as those whose misconduct can deprive the ship owner of the right to limit liability. Consequently, the approach taken by individual states to corporate attribution is a matter which might not result in equal results from equal rules. And this is something on which all the maritime conventions are entirely silent, and where resort to national law is all that one has. Different methods of attribution of corporate responsibility in relation to both civil and criminal liability have developed over the past century. And each of these models conceptualises the capacity of the corporation to be criminally or civilly responsible in different ways. The more traditional methods of attribution conceptualise corporate fault in a narrow way with reference to particular individual actors. Nevertheless, even the traditional methods of attribution model corporate fault in different ways. The approach taken in this country and in South Africa, South Australia is not a country, is through the doctrine of vicarious liability. And this approach to corporate attribution makes a corporation responsible for the acts and mental states of its agents, either through making the corporation liable for the agent's conduct or liable for the agent's own liability. Corporate criminal responsibility is established derivatively under such a model. Identification theory, on the other hand, ascribes the conduct and states of minds of particular individuals to the corporation itself, and the conduct and states of minds of those individuals are considered by the law to be those of the corporation, and they usually talk in terms of a high managerial agent, a director or a board member. And the plus or minus meridian is a reference to a decision in England where the rule was taken to look for the person in the organisation who in fact had responsibility for making the decision and taking his or her knowledge as being that of the corporations. Now, that's the approach that's dominant in the United Kingdom, in Canada, and in New Zealand. And it is also the predominant position in Australia. We look to the directing mind and will of the corporation. Australia has, however, made significant statutory changes to methods of corporate attribution in relation to both criminal offences and civil penalty provisions. The most widely used method of attribution of responsibility is based on a method that first appeared in what was then Section 84 of the Trade Practices Act of 1974. Under that method of attribution, corporations are responsible based on the state of mind of a director, employee, or agent. And although attribution based on that model predominates across the Australian statute book, it's by no means a uniform approach. And there are many variations of the TPA model. More radically, or some people say just more holistically, different approaches to criminal responsibility have emerged in recent decades. And these approaches focus on organisational blameworthiness. And the theory of organisational blameworthiness interrogates the issue of corporate fault in relation to the corporation itself, not to one or more individuals. And although identification theory does this also in a sense through providing for direct liability of a corporation through the individual, under organisational models, corporate criminal responsibility does not need to be mediated through particular individual actors. The corporation itself has a distinct and identifiable personality independent of specific individuals. Now, an example of this approach is found in Part 2.5 of our Commonwealth Criminal Code. Now, like the US, Australia is a federation, and each state has responsibility for criminal law within its state, but the Commonwealth as a whole has responsibility for offences that are created under federal statutes. So this is the federal criminal code. And Part 2.5 of the code sets out the legal tests for attributing the physical and fault elements, so the actus reus and the mens reus of an offence, to corporations. And the most innovative aspects of Part 2.5 are located in a particular section which permits the fault elements of intention, knowledge, and recklessness to be attributed through a corporation's board of directors, a high managerial agent. So far, that's just restating identification theory, but also through its corporate culture. And it provides that authorisation or permission to commit the offence may be established by proving that a corporate culture existed within the body corporate that directed, encouraged, tolerated, or led to non-compliance with the relevant provision. So this is a focus on the systems, the policies, the procedures of a company. And if they're found to be a dud, then you can hold potentially the corporation criminally or liable to a civil penalty through this method of corporate attribution. Now, despite this very novel approach, and despite it having been enacted for several decades now, it has not been widely adopted across the statute book, and indeed is expressly excluded from some of the most important statutes in the maritime sphere, including the Fisheries Management Act and our statutes that implement MARPOL and the CLC. Rather, they are directed to use the TPA model. But one of the very few cases, in fact, really the only one that I have been able to find that considers the operation of the corporate culture provisions occurred in a maritime case. And that was in the Queen and Potter and Muir's Fishing Proprietary Limited in 2015. In that case, it was alleged that the corporation failed to create and maintain a corporate culture that required compliance with a provision of the criminal code that made it an offence to do anything with the intention of dishonestly influencing a public official. and the transgression in this case was the falsification of the vessel's log. The trial judge, though, directed an acquittal, so he didn't even let the matter go to the jury. Chief Justice Blow concluded that the prosecution had pointed to no evidence from which a reasonable inference could be drawn that any aspect of Muir's corporate culture directed or encouraged the dishonest influence of any officials or involved tolerating any such offence or led to any such offence being committed. He said there is little or no evidence as to the corporate culture features of the corporation generally. Now, all of this is to say that while on their face, nation states may adopt international conventions in similar or identical terms, precisely what the interpretation is applied to comes down to a question of domestic law about which there is unlikely to be any uniformity. Professor Nick Gaskell has observed that because the LLMC is silent on the issue of attribution, there is great scope for differences in approach, especially in courts where maritime law is not a specialism. Now let's turn to the meaning of loss and damage and how this has been interpreted by various courts. So Article 2(1)(a) of the LLMC contemplates these 4 types of claims for which liability may be limited. But there's no universally accepted view as to what is included within the phrase consequential loss resulting therefrom. The phrase could relate to further loss or damage resulting from, for example, loss of property, being bunkers, pollution on beaches and resulting cleanup costs, economic losses caused, for example, to fishermen and tourist operators. Alternatively, the losses referred to may be confined to consequential loss in the narrow sense, that is, losses caused to the property owner consequential on the loss of or damage to the owner's property. Now, in the CLC and fund conventions, pollution damage is defined to mean loss or damage caused outside the ship carrying oil. It refers to impairment of the environment other than loss of profit from such impairment, and the cost of preventative measures and further loss or damage caused by those measures. Now, Mons Jacobsen, the former director of the International Oil Pollution Compensation Funds, has observed there is a significant difference between common law countries and civil legal systems where claims for pure economic loss, sometimes referred to as consequential loss, are concerned. And even as between common law countries themselves, the approaches differ along a spectrum. The narrower view is preferred in the UK, whereas Australia has taken a wider approach. It is similarly true that not all civilian systems are the same. Further, there are jurisdictions such as Spain and France where awards for non-economic loss are available, including for non-economic damage to the environment, such as moral damage, which includes loss of enjoyment and damage to reputation and brand image. These are not heads of damage recognised in any of the maritime limitation conventions. So in response to this panoply of approaches, the IOPC developed a set of criteria published as guidelines in its claims manual, along with technical guidelines, by which it explains how claims for pure economic loss qualify for compensation under their funds. And clause 3.3.4 provides that claims for pure economic loss qualify for compensation only if they are for loss or damage caused by contamination. And in order for a claim for pure economic loss to be accepted, there should be a sufficiently close link of causation between the contamination and the loss or damage. And the fund considers these factors: the geographic proximity of the business to the contaminated area, the degree to which the business is economically dependent on the affected resource, the extent to which you can find alternative supply opportunities, and the extent to which the business forms an integral part of the economic activity within the area affected by the spill. And whilst these guidelines are helpful soft law instruments, the basic principle underlying the CLC and the Fund Convention is that disputes concerning the interpretation of the Convention are adjudicated before the courts of the states where the pollution occurred. So national courts are therefore the ultimate arbiters, and it doesn't really matter what the claims manual says from the point of view of those national courts. Now, the litigation that's flowed from the Prestige disaster off the coast of Spain and France in 2002 is illustrative of the consequences that may flow from a lack of uniformity in the interpretation of these conventions, and is perhaps a precursor to what you are about to face in this country arising from the Dali. So it was November 13, 2002, while sailing off the coast of Spain, that the Prestige, 25-year-old oil tanker carrying 77,000 tonnes of persistent heavy fuel oil, began to list dramatically and leaked fuel oil into the sea. Spain successfully rescued the crew and then forced the tanker on an erratic course out of Spanish waters. On November 19, the tanker broke in two and then it sank, and her fuel oil cargo contaminated thousands of kilometres of the Spanish and French coastlines. One only needs to observe that two decisions of the English High Court arising from this disaster were delivered in October 2023 and may still be subject to appeal. So more than a decade after the disaster, the litigation is more persistent than the oil. I do not propose to critique the numerous decisions that have been made in the course of this matter in the courts of Spain, France, the UK, and the District Court in New York over the past decade. I just want to highlight some of the matters of particular concern that arose from the decisions of the Spanish Supreme Court of Cassation. The first decision on February 19, 2016, reversed a decision that had been made in the Coruña Court of Appeal. The Supreme Court held the master criminally liable for reckless damage to the environment. Having done so, the Supreme Court permitted the limit that I've already referred to, that Article 4 limit, to be broken, such that the P&I Club's liability for the master and the ship owner's liability was unlimited up to the policy limit of US $1 billion. Now, that was significantly higher than was provided for in the convention. The Supreme Court also recognised the possibility of moral damage, which included not only the sense of fear, anger and frustration that may have affected many of the Spanish and French citizens, but also the mark that may have been left by the notion that catastrophes like the Prestige incident could affect these citizens at any time. The case was referred back to the Coruña Court for the assessment of damages. That assessment was ultimately appealed, and on December 19, 2018, the Supreme Court confirmed that the London P&I Club was liable for all the damages caused by the incident, including pure environmental and moral damages up to the limit of the policy. It did, however, clarify that those damages were not recoverable from the CLC, but were from the master, the ship owner, and the P&I Club. And the basis for that finding is wholly unclear, and was despite the fact that Article 8, Rule 8, expressly provides that the insurer may avail himself of the limit of liability. Now, shortly after that judgment was delivered, the director of the IOPC funds, who I think at the time was still Mons Jacobsen, expressed the view that it created a dangerous precedent which other courts might follow in future cases, and that endangered the uniform application of the CLC and fund conventions. Consequent upon the apparent disharmony that was emerging across jurisdictions, in 2021, the Assembly of the IMO adopted two resolutions in relation to the interpretation of Article 4 of the LLMC 76 and 96 and its equivalent in the CLC and the fund. And its reasoning was made extremely clear. They said, we are concerned that the inconsistent application of the interpretation of the test for breaking the right to limit has resulted or could result in uncertainty and unequal treatment of claimants. The resolution went on to affirm that Article 4 is to be interpreted as virtually unbreakable, to mean a level of culpability analogous to willful misconduct. In other words, only if your insurer is not going to pay should you be liable under this. That the term recklessly is to be accompanied by knowledge, as it has been interpreted by the English and the Australian and the Canadian courts over many decades, and that the conduct of parties other than the ship owner is irrelevant to whether the test has been met. Now, this resolution goes some way to clarifying the interpretation of Article 4, at least in respect of some of the matters arising out of the Spanish decisions in the Prestige. In particular, it has reiterated the intention of the 96 protocol and the level of culpability. It provides no assistance at all in relation to the question of corporate attribution. Now, the legal saga of the Prestige is far from the only example of the extraordinary amount of time and money that might be consumed when states take differing approaches to the interpretation and application of the same convention. And Martin will understand why I hesitate to quote Professor Gans, but in a remarkably sensible observation, Professor Gans of the University of Melbourne said, in order for the unifying purpose of the convention to be achieved, it is not sufficient that the convention enters into force, but it must also be implemented in the domestic law of the state parties and be interpreted and applied in the correct manner. A major problem is that national courts, and I interpolate, and legislatures, sometimes wittingly or unwittingly misinterpret or deliberately ignore the provisions of applicable conventions to the detriment of unification. So have we cause for optimism or pessimism? If we agree that uniformity, as far as it goes, in international maritime law is desirable, then where do we go to from here? Is there any will to reverse the fragmentation that's appearing? And there are two developments that perhaps give us some cause for optimism. The first is the development of the soft law tools like the IMO's resolution. And the second is the willingness of certain states to embed the notion of reciprocity into international law. The resolution in relation to Article 4 is just one in a series of resolutions directed at the interpretation of various provisions of IMO conventions. Another recent one concerns the interpretation of SOLAS. And the method of agreeing such resolutions is by adoption at the IMO Assembly by the Conference of State Parties. But this is where we drift into public international law. And under international treaty law, the only legitimate way to carry out a variation to the convention by interpretation is via the consent of all parties to the convention. So there may well be a question as to whether the resolution in relation to Article 4 is valid because only 95% of state parties have adopted that resolution. And then the second method might be the potential for reciprocity between states. And this speaks to the willingness of national courts to recognise and enforce other courts' decisions and follow their interpretations on particular aspects of maritime law. And in the landmark case of Ju 72 JY Ren number 1, the Shanghai Maritime Court decision, the People's Supreme Court enforced the judgment of the High Court of the United Kingdom in Grand China Logistics Holdings and Spa Shipping. And that was pursuant to a power that was in the Chinese civil procedure law. The qualification is that it is subject to another provision of Chinese civil procedure law that specifies that such recognition will only occur if the People's Court deems that the judgment does not violate the basic principles of the laws of the People's Republic of China and the sovereignty, security, and public interest of the People's Republic of China. But nonetheless, there has been some very strong indications from the Chinese courts in the last couple of years that show that reciprocity is beginning to be embedded in their thinking about international maritime law. So in conclusion, my hope is that states will prioritise true uniform law as a matter of foreign policy. My lingering fear, however, is that we've reached peak levels of uniformity and may well be on the downward slide. That is evidenced by the creation of alternative rules in areas where relative uniformity had already been achieved, such as the Rotterdam Rules, and the adaptation of conventions in national legislation to suit local conditions, for example, the Australian rules and the Chinese Maritime Rules, Chinese Maritime Code, even in circumstances where nations such as Australia purport under public international law to continue to adhere to a convention, which it makes no sense to me at all. It's also evidenced by the perceived need for peak international organisations like the IMO to produce guidelines and interpretative resolutions that may or may not accord with the text of the convention as originally agreed, and may or may not reflect the agreement of all state parties to such resolutions. Now, if the downward slide is as a consequence of the demise of globalisation, as I posit, there may be nothing that a community of like-minded people for whom maritime and shipping activities are central to their livelihood to do at this stage. In 1999, William Tetley wrote, "World society is not yet ready for a monolithic international law. It cannot give up its diversity of social purpose and manner of doing things. International laws in any form must recognise this diversity in substance and style, or they will fail. They must avoid imposing one legal system or legal tradition at the cost of marginalising another." Those words, I suggest, ring even more truly today. Thank you all for your attention.
Thank you very much, sir. Don't go. I promised, well, no, I threatened Sarah that there may be questions afterwards. Yes?
I just like to get your thoughts on, especially like you're talking about this uniformity through foreign policy, but especially in those regional economic, like comprehensive frameworks like RCEP, where the whole ASEAN and Australia, New Zealand, China, and Japan isn't, would that help in terms of uniformity, having some sort of framework, rather than like individual, attempt to?
The EU is the only organisation that seems able, that is, I think, permitted to sign conventions. So I don't know that that would necessarily help in the maritime context, apart from getting together and talking about it and saying this is all a good idea. A more recent example is the Judicial Sales Convention and trying to get people to sign. Are you signing up to that?
I wouldn't think so.
No. So
Beijing Convention.
the Beijing Convention. Yeah. So but what happens at CMI meetings is that we all sit around a table as representatives of maritime law associations in a room like this, and we are urged to go back to our governments and urge our governments to sign up to the conventions. And as I say, these are not matters about which politicians really have very much interest at all. So it's difficult, really difficult to do.
Hey.
I was wondering how you see the relationship between Australian consumer law and maritime law, especially in the wake of the High Court's Carpick decision and the potential for Australia to be seen as a hub for class actions.
Bring it on. Where are we up to with Carpick? It's gone back to the trial judge, hasn't it?
Yeah,
It's gone back to,
he's issued his findings on it.
yes. It is tricky, and I think Australia is already seen as a hub for class actions. We are outstripping Canada. We haven't quite got to your level of class actions, but it is something that is being fiercely driven by litigation funders in Australia. It has become an enormous industry. So I can tell you that wherever there is a gap like emerged in CAPIC, the litigation funders and the plaintiff lawyers are all over it. And I just think that is a consequence of what will happen. Yeah.
I noticed that you also have a background in insurance. And this may be very naive, but it seems to me that a continued driver toward uniformity and a sense of predictability, especially as ships get bigger, cargo gets more expensive, more dangerous, that the availability of insurance has to be a driver toward some sort of uniformity / predictability.
I think you're absolutely right. And because I knew that you'd already be falling asleep by this time, I cut out the whole section of my paper that was on insurance. And the disappointing thing that has happened is that England has moved to its new Insurance Act. Nobody has followed it as yet. And what was the beacon of uniformity, being the Marine Insurance Act, which we all grew up with and loved, has gone by the wayside. I once was across what the Norwegian insurance plan was doing and where that fitted in the schema. I'm not sure if you know where that all. You've never known where that fits now, but I think you're absolutely right. And it's a question for the insurers to work out which regime they want and push for it. The marine insurance industry in Australia, such as it is, which is, virtually nothing, do not want to adopt the English model, and they don't want to make any amendments to our Marine Insurance Act, which is the identical version of the old English Act.
If I could add, I mean, I completely agree. I think insurance is a really good example of this fracturing that you're talking about. I've written that given the changes in the English law, it actually makes sense for brokers in places like the United States and Australia to advise their clients to insure to insure in the London market, which is more favourable to the insured.
Yeah, exactly.
David.
Justice, thanks so much for coming to Tulane. I want to apologize. 4 of my students are being recruited by law firms in New York right now, so most of my classes are not here.
It's much more important for them that they are in New York.
So my question has to deal with the disruption of international sea lanes, but particularly those off the coast of Yemen. So we went through a period recently, up until January of this year, where we did not have a large number of warships that responded to the aggression of some of the Houthi tribes people attacking commercial vessels. There have been bill of ladings disputes that arose after the UK and the United States sent warships into these small areas because they didn't announce that they were sending the warships there. And the sailors on the ships had no idea where the ships were going.
I'm not aware of any yet, but I have no doubt that there will be. And I know that there's been a lot of activity about the war cover clauses in the charter parties. And so it will come. It will come. But now you're going to have a similar problem. You've got another sea lane that's seriously disrupted. So that makes 5 by my count at the moment. So anybody who's waiting for goods to be shipped around the world at the moment should not be holding their breath. It's a terrible mess.
Any other questions? If not, join me in thanking Sarah Derrington again and join us.